morning, everybody, and welcome to this edition of the Radcliffe Chambers Junior Programme. Today we're looking broadly at some property topics. So my name is Natalie, and I'm one of the junior barristers in Chambers, and I'm joined by Louis, who's in his very learned office, and he is also one of the junior barristers in Chambers. If you have attended one of these junior programmes online before, it's going to be the same format with which you're already familiar. So we're going to have two presentations, roughly of about 20 to 30 minutes each. There will hopefully be some time for questions at the end. So if you have any questions that occur to you as we're going through, please pop them in the Q&A box that you should find on the menu bar at the bottom. If for some reason we don't have time to answer your questions because I overstay my welcome and talk too much, or if you don't think of your questions until much later on, that's absolutely fine. You can send them across in an email and we'll deal with them that way. So I think that's probably all the housekeeping. I think we have all the numbers that we're expecting for the moment. So I shall hand over to Louis.
Great, thanks very much, Natalie. I'm just going to share my screen. So 2023 has been an extraordinary year for the law of nuisance, and particularly the law of private nuisance. There have been a succession of cases dealing with different aspects of the doctrine, which are now either of fundamental importance or which represent very significant chapters in the development of the doctrine. So there are 5 cases which I'd like to bring to your attention. The first is the decision of the Supreme Court in Fearn and Board of Trustees of the Tate Gallery. This really is fundamental in that it represents the most significant modern restatement of the essential features of private nuisance. The second is another decision of the Supreme Court in Jalla and Shell International Trading. This is also, I think, fundamental, albeit in a more modest way, as it's now the leading authority on what counts as a continuing nuisance. The third case is called Davies and Bridgend Borough Council. It's a decision of the Court of Appeal which addressed the question whether, in a case of nuisance by encroachment of Japanese knotweed, damages for the diminution in value of the property are recoverable. It contains important statements of principle, but I understand that the Supreme Court has also now granted permission to appeal in this case, so we can expect yet another decision of the Supreme Court in private nuisance relatively soon. Now, those are the 3 cases which I'm going to focus on in this talk. But I wanted to flag 2 other significant cases of which I think property lawyers should be aware of. The first is Manchester Ship Canal Company Limited. Now, in March, the Supreme Court heard the appeal in this case. The issue is whether a landowner can bring a private law claim in nuisance and or trespass against a sewerage undertaker in respect of unauthorized discharges onto its land, into its a canal, or whether that would be inconsistent with the applicable statutory scheme. Now, at first sight, that sounds like a rather narrow niche question, but it's worth having on your radars, as the decision of the Supreme Court may have wider repercussions for the law of nuisance, particularly as one of the issues raised by Fearn going forwards is how nuisance interacts or doesn't interact with other statutory schemes, for example, planning law. Secondly, there have been a very significant number of cases over the past year in which claims in nuisance have been brought in respect of protest activity. So a recent example is National Highways Limited in the Court of Appeal, but the issue also arose in a case in which Natalie appeared earlier this year in the Supreme Court called Wolverhampton City Council and London Gypsies and Travellers. Now, the contentious issues in these cases have tended to be concerned less with the substantive law of nuisance and more with remedies and the availability of injunctive relief, particularly against persons unknown. I don't want to trespass on Natalie's talk, so I'll say no more about that, except to flag that this is an area where there's a considerable amount of case law at the moment and where the law, I think, is in a state of flux. So with that, I will turn to Fearn. The facts, I think, are well known. The claimants owned flats on the upper floors of the Neo Bankside development, which you can see they're the glass buildings on the right-hand side of the image. Opposite the viewing gallery on the top floor of the Tate Modern's Blavatnik building, which is the Blavatnik building is the brick building on the left of the image, and you can see the viewing gallery at the very top. Now, each year, around 500,000 to 600,000 people visit the viewing gallery, of which a significant number, the judge found at first instance, displayed an interest in the claimant's flats, which are, as you can see, constructed mainly of glass. So some would look, some would photograph, some would wave, some would use binoculars, and many photographs of the flats were posted on social media. So the claimants brought a claim in private nuisance, seeking an injunction requiring the Tate to prevent members of the public from viewing their flats from the gallery. That claim failed in the High Court and in the Court of Appeal, albeit for different reasons. Now, in the High Court, Mr. Justice Mann held, in essence, that the Tate's use of the top floor of the Blavatnik building was reasonable, and that the claimants were responsible for their own misfortune because they could have taken remedial steps. They could have installed curtains or privacy screens or whatever. The Court of Appeal considered that Mr. Justice Mann had made a number of errors in his application of the law of nuisance, but it considered nonetheless that the claim should fail because, as a matter of law, overlooking was incapable of amounting to a nuisance. So the claim failed both in the High Court and in the Court of Appeal. The claimants appealed to the Supreme Court, and the Supreme Court allowed the appeal. Lord Leggatt, with whom Lord Reid, the President, and Lord Lloyd-Jones agreed, gave the majority judgment, and Lord Sales, with whom Lord Kitchen agreed, gave a dissenting judgment. Now, Lord Leggatt considered that each of the courts below had misapplied the core principles of private nuisance. And his restatement of those principles is, I think, the most important summary of the law in this area. He identifies 8 core principles. Now, first, private nuisance, he tells us, is concerned with wrongful interference with the claimant's enjoyment to rights over land. The harm from which it protects is the diminution in the utility and amenity value of the claimant's land, not personal discomfort to the occupants of it. I think that's relatively uncontroversial. Secondly, more controversially, Lord Leggatt held that there is no conceptual limit to what can constitute a nuisance. Anything short of direct trespass on the claimant's land, which materially interferes with the claimant's enjoyment of rights in the land, is capable, in principle, of being a nuisance. There's no requirement that the nuisance be caused by a physical invasion of your land, of the claimant's land, or by an emanation from the neighbouring land. It follows then that people constantly looking into your land can, in principle, constitute a nuisance. Thirdly, one must ask not simply whether the interference was unreasonable or whether the defendant's use of the land was reasonable user. That language has, Lord Leggatt considered, no explanatory force whatsoever. If you're asking the question, is it reasonable? You don't have the means with which to answer the question. That's a fundamental problem he identifies. So one must ask instead, Lord Leggatt says, whether there has been a substantial interference with the ordinary use of the claimant's land. We'll come on to this, but this potentially represents a significant development in the law in this area. Fourthly, the test for what counts as a substantial interference is objective. And fifth, this is what Lord Leggatt described as a fundamental feature of the law of private nuisance. The law accords priority to the general and ordinary use of land over more particular and uncommon uses. So the governing principle is one of reciprocity. A person using their land in a common and ordinary way is not seeking any unequal treatment or asking of their neighbours more than they ask of them. One aspect of this is that even in the event of substantial interference with the enjoyment of the claimant's land, there will be no liability if the activity is itself no more than the ordinary use of the defendant's own land. Another aspect of that, and this is a critical difference with Lord Sales's judgment, is that the occupier cannot complain if the use interfered with is not an ordinary use. In other words, if the defendant's use of the land is not common and ordinary, they can't rely on any arguments about reciprocity by looking at the claimant's own position. And we'll come on to see how that applies in the context of this case. Sixth, what is a common and ordinary use of the land is to be judged by reference to the character of the locality. That's established in the authorities. Seventh, again, uncontroversial, coming to a nuisance is not a defence. And finally, it's no defence to an action in nuisance that the activity is of public benefit, although that may be relevant to the question of remedies. So Lord Legate considered that the application of these principles to the facts of Fearn was entirely straightforward. The level of intrusion, it was clear on the judge's findings, caused a substantial interference with the ordinary use and enjoyment of the claimant's properties. And inviting members of the public to look out from a viewing gallery was a particular and exceptional use of land. It could not, he said, even be said to be an ordinary incident of operating a museum. And this is the point on which he differed with on which the minority departed, really, is that he then said that because inviting members of the public to look out from a public gallery is a particular and exceptional use of land, the Tate could not say that it seeks no more toleration from its neighbours for its activities than they would expect the Tate to show for them. There was no room then for the Tate to make any arguments about reciprocity here. That leaves, though, the question of remedies. And it's in that context that the question whether there's a public interest in maintaining the viewing gallery should be considered. It's in that context whether you should consider whether there's any possible remedial action short of an injunction, which could be contemplated here, or indeed whether damages should be awarded to the claimants in lieu of an injunction. So those questions have all been remitted to the High Court. Now, Lord Legate's restatement seeks to dispel what he presents as misunderstandings or mistakes. But in doing so, I think there's an argument that he has quite radically reformulated the law in this area, if only by bringing clarity to it. Now, Lord Sales describes Lord Legate's judgment as affecting, in his words, quote, a major change in the law. And that's why the restatement is so important. If you do not look at it, there's a risk that you're getting things wrong, even if you're looking only at the authorities which have not been formally called into question by Fearn. Fearn doesn't present itself as departing from authority, but simply as recalling it. That's a word that Lord Legate uses. But in bringing clarity now to private nuisance, I think there is an argument that he has reformulated or restated the principles. Now, Lord Sales, for the minority, agreed that overlooking was in principle capable of being actionable in private nuisance if it amounted to a visual intrusion. But he considered that in making common and ordinary use the most important feature of the analysis, Lord Legate's approach involved a significant departure or revision of the reasonable user principle, because it involves looking at the reasonableness of each party's use of the land in isolation. On Lord Legate's account, there's no room, as I've said, to consider whether the claimants should consider remedial measures, because that would amount to blaming the victim. It's the defendants who've been using their land in an extraordinary way. But on Lord Sales's account, private nuisance is concerned to maximise the freedom of neighbouring landowners in a symmetrical way. That's the language he uses. And it does so with a principle of give and take between neighbouring occupiers of land. So it cannot be reduced to the question whether the defendant's use of the land is common and ordinary. That places excessive weight, Lord Sales says, on one side of what is an inextricably two-sided relationship. So the court should instead, Lord Sales says, analyse the interaction between the ways in which each party is using the land. And in that respect, it's appropriate to consider the reasonable self-help measures which might be available to protect oneself against visual intrusion by neighbours in an urban environment. So it was relevant for Mr. Justice Mann to consider that the claimants could put up curtains or privacy screens and so on. So Lord Sales would have upheld the judgment on at first instance, essentially for the reasons which Mr. Justice Mann gave. Although I should say Lord Sales has his judgment is very full, and it contains a lot of quite involved analysis of the case law. So he doesn't simply adopt what Mr. Justice Mann said. He adopts his conclusions, essentially because of the Mr. Justice Mann's assessment of the facts, which he then justifies with Lord Sells's own analysis of the case law in this area. So standing back, I think the decision in Fearn does potentially involve a significant expansion of what would amount to an actionable nuisance, because it's much clearer now that this is not an inquiry into reasonableness, which is completely at large. Instead, you ask only, effectively, whether there is a substantial interference with the ordinary use of the claimant's land. And you only balance competing considerations if both parties are making a common and ordinary use of their land. Now, that still, of course, begs the question of remedies. The effects of Lord Legate's judgment, in a sense, is to displace much of the judicial balancing of interests to the remedial stage, which I think Natalie is going to talk to you about, rather than the stage at which liability is established. So although, and this is, I think, of direct relevance to practitioners, it may be easier to offer predictions on the question of liability, and it's more likely that liability will be established, I think, for the most part. One must still consider carefully whether, if liability is established, there are remedial options short of an injunction, which could be available. I'd like now to turn to the next case, Jalla, Jalla and Shell International Trading. Now, this was a claim in nuisance brought by 2 Nigerian nationals against Shell in respect of damage to their land caused by an oil spill. Now, that spill was itself caused by a leak from an offshore installation, which you can see on the left of the screen, in December 2011. That leak was fixed within 6 hours, but it resulted in over 40,000 barrels of crude oil migrating to a large stretch of land in the Niger Delta. Shell didn't clean it up. It wasn't their land, but they didn't clean it up. And so the question was whether the fact that the oil was still present on the land and had not been removed meant that there was a continuing nuisance, such as to give rise to a continuing cause of action, which runs afresh from day to day. If it was a continuing nuisance, the claimant's action would not be time-barred. If it wasn't a continuing nuisance, the claimant's action would be time-barred, and that resulted from the way in which they'd chosen their defendants. They had to amend their pleadings to add a defendant, and that amendment would have been time-barred. Now, here, the unanimous judgment of the Supreme Court this time was given by Lord Burrows. He held that there was no continuing nuisance because essentially there was no repeated activity by the defendants or an ongoing state of affairs for which the defendants were responsible that was causing undue interference with the claimant's use and enjoyment of their land. There was simply a leak, which was a one-off event, which wasn't continuing for any stretch of time after the 6 hours during which it lasted. That conclusion strikes me as fairly uncontroversial on the facts. If the claimants had succeeded, it would effectively convert, if you like, the tort of private nuisance into a failure by the defendant to restore the claimant's land. You would have this continuing obligation to restore the claimant's land to the position it was in before the event occurred, and that would be the liability and nuisance. I think the more interesting feature of this case is the indication that Lord Burrows gives that in the normal case, those are the words he uses, the tort of nuisance is continuing. So that nuisance, as conceptualized by Lord Burrows, is normally a regular activity by the defendant or an ongoing state of affairs for which the defendant is responsible. That was precisely the reason, Lord Burrows says, why an injunction is the default remedy for nuisance. If the nuisance isn't continuing at the time at which remedy is sought, there's no scope for granting an injunction. But the question this raises, and I've anticipated a bit the points on the slides, is whether a one-off event or an isolated escape can ever amount to a private nuisance at all. One might have thought pre-Jalla that yes, it could, and there were statements in the authorities that it can. There are statements in some of the older authorities that it can't, but it hadn't really been called into question. certainly hadn't been called into question below, and the judge at first instance in Jalla assumed that the core example of nuisance was effectively a one-off leak from one land, which causes a damage to neighbouring land. But Lord Burrows makes clear that it had been assumed for the purposes of the appeal that a nuisance could be committed by a single one-off event, and they had argument on that, but then they declined to decide whether a nuisance could be committed by a single one-off event because it didn't have to on the facts. But the fact that it makes clear that it assumed that it could be caused but didn't decide the question means that the question remains open. And I think, probably not reading too much into it, that there's sufficient doubt about the question that they declined to decide it in the appeal. Now, as I've said, there's some Court of Appeal authority that private nuisance always involves some degree of repetition or continuance. But I can't help but, and that's the case of Attorney General and PYA Quarries, it's a Lord Denning case, so it's relatively old now. But I can't help but think that even asking the question whether a nuisance can be constituted by a one-off event may be in tension with the clear statement in Fearn, which preceded Jalla. So Jalla refers to the Supreme Court's decision in Fearn. The statement there that there is no conceptual limit to what can constitute a nuisance. It also, I think, raised the question of what is meant by a one-off event or isolated escape. That's how the Supreme Court described the leak in Jalla, but that lasted 6 hours. So if it's right that a leak lasting 6 hours can be a one-off event, the decision seems to suggest that there's a broad category of cases which are properly viewed as involving a one-off event or isolated escape, which, as matters stand, may or may not be capable of giving rise to an actionable nuisance. And that creates, I think, some doubt. The final case I want to discuss is Davies and Bridgend Borough Council. This was a claim in nuisance in respect of the residual diminution in the value of the claimant's land, which resulted from an encroachment of Japanese knotweed from the defendant's neighbouring property. What had happened was that the claimant bought his property in 2004. By that point, the defendant's knotweed had already spread onto it. The knotweed was then treated, but the claimant argued that the prior encroachment had blighted the property's value and resulted in the residual diminution in value, because I think effectively the concern is that if the property has once been infected with knotweed, there's always a concern that it can come back. So the court found below, at first instance, that there had been a continuing nuisance between 2013, which was the date by which the defendant should have known that the spread of knotweed was a nuisance, and 2018, when the defendant started abating the nuisance by implementing a treatment plan. Now, the claim here was for the, as I've said, the residual diminution in value to the claimant's land. The judge at first instance had held that absent any physical damage to the claimant's property, damages for diminution in value were irrecoverable in nuisance, because that would amount to recovery for pure economic loss. The Court of Appeal disagreed. The confusion stemmed from a line in a previous decision of the Court of Appeal called Williams and Network Rail, in which the court had held that the presence of knotweed on neighbouring land did not become an actionable nuisance because it diminished the value of the claimant's land. But once the knotweed is present on the claimant's land, once it jumps over, encroaches, such as to diminish the claimant's enjoyment of that land, that does give rise to a claimant a nuisance. And if you can prove consequential residual diminution in value, you can recover damages on that basis. That was what the Court of Appeal decided or clarified in Davies. I should say that the damages here were pretty modest. They were agreed to be £4,900. There was also an issue about causation. The defendant had argued that because one, the knotweed had encroached onto the claimant's land long before the defendant was in breach, because the defendant only acquired the necessary knowledge in 2013, and because two, the diminution in value of the claimant's property was caused by the mere presence of the knotweed on its land, there was no causation flowing from the defendant's continuing failure to abate the nuisance. The damage, in other words, to the claimant's land was already done, and the ongoing failure of the defendant to stop the encroachment after 2013 made no difference to that fact, because the damage was done. So the defendant argued there was no causation and no actual nuisance. The court rejected this argument. It said that because the encroachment was ongoing until 2018, causation could be established on the basis that any attempt by the claimant to clear the knotweed on his own land would have been futile without the cooperation of the defendant. In other words, as soon as the claimant cleared his own knotweed, it would have been replaced by fresh knotweed from the defendant's land, unless and until the defendant abated the knotweed on their own land, which they didn't do sufficiently until 2018. So on that basis, the nuisance was a continuing nuisance. The decision, I think, though, gives rise to a few questions. One is whether it's correct to say, in the light of Fearn, that a physical encroachment by knotweed onto the claimant's land is necessary to recover for any diminution in value. That's clear from the Court of Appeal authorities. But if it's right, and this is what Lord Legate tells us, that the basis of the claim is not, quoting, and I'm quoting here from his judgment, the physical invasion itself, but the resulting interference with the utility or amenity value of the claimant's land, I think it seems that the presence of untreated knotweed on neighbouring land could, in theory, be enough to constitute a nuisance. And that would seem clear enough where, for example, the claimant has to expend sums to keep the knotweed at bay, but the presence of knotweed on neighbouring land has already caused damage, say diminution in the property value of their land. As I say, though, permission to appeal to the Supreme Court has been granted in this case. I don't know on what basis, though, so we may get additional clarification in this area relatively soon. So drawing these strands together, the key points to take away are, one, Fearn is fundamental. It's important, it can't be overstated. Although the majority judgment, as I've said, is framed as recalling the core principles of private nuisance, they can properly be viewed as a reformulation, or at any rate as clearly pinning colours to a mast and clarifying the applicable principles. What might not previously have amounted to a nuisance with an open-ended inquiry into reasonable user might well now, I think, amount to a nuisance. And those principles will reverberate through the existing authorities. I think I've tried to show how they can already have some bearing on questions left open by Jalla, such as whether a one-off event can be a nuisance, or in Davies, such as whether a requirement for physical encroachment by knotweed is necessary to recover damages. This is, though, by no means, Fearn, or any of these cases are by no means the last word from the Supreme Court for the foreseeable future. The position may evolve further with the forthcoming decisions in Manchester Ship Canal, probably less likely to be to engage with the fundamental principles, but it may have some importance for its interaction with statutory schemes, for the interaction of nuisance and statutory schemes, and of course Davies itself. That's what I wanted to say about that, and so I will hand you over to Natalie.
Thank you, Louis. So I'm going to follow on from Louis, and I'm going to look at one of the remedies that you might seek in a claim for private nuisance. And that remedy is, as Louis has already mentioned, an injunction. So I'm going to do four things. I'm going to do the first three of them, hopefully very quickly, and spend most of my time on bullet point number 4. So very, very quickly, we'll have a look at what an injunction is. I'm sure you already all know that. Have a quick think about when you might be seeking injunctive relief, perhaps as compared to other remedies. Give a very brief procedural overview that you might need when you're seeking injunctive relief, and then spend most of my time looking at my 10 top tips when seeking injunctive relief. I call them top tips. I think on reflection, there are probably more themes around which I will talk. So, starting at the beginning, what is an injunction? So Louis has already mentioned it's a remedy, and it's one of the remedies that may be available if you have a successful claim in private nuisance. So broadly speaking, an injunction is a remedy that's available if there is interference with property, or perhaps more accurately, interference with proprietary rights. But as we probably all know, that's not the only circumstance in which the remedy is available, but it's certainly, for our purposes of property lawyers, a key one. Whilst it is a remedy, or whilst an injunction is a remedy, it's not necessarily, or it doesn't have to be tied itself to a cause of action. So the Privy Council have looked at this in the Broad Idea and Convoy collateral case in 2021. So you can have a freezing order, for example, to aid enforcement of a judgment, even if the assets that are to be frozen are not the subject matter of the proceedings. And we also know that we can have, say, for example, post-judgment freezing orders, and also freezing orders to aid the enforcement of cost awards. So whilst it's a remedy, it's not necessarily itself tied to a cause of action. We have lots of different species and types and subtypes of injunctions. So we know that there's a distinction between those that are interim and final, so those that we seek prior to the final hearing of a claim in order to halt the ring up until final disposal. If we are seeking interim injunctions, we know that we might need to seek those either without notice or with notice. I'll look at the distinction a little more when I do my 10 top tips. You might be looking for a prohibitory or a mandatory injunction. So your prohibitory one would say defendant must not do something, whereas the mandatory injunction would require the defendant to do something. And then you have a distinction between your, what I've called reactionary and precautionary injunctions. Now, precautionary injunctions are what we all until fairly recently were calling quia time relief. The Master of the Rolls in the Court of Appeal in the Barking and Dagenham litigation was very clear that we should be moving away from Latin terminology. So quia time relief is now properly called, I think, precautionary relief, and that's the terminology that the Master of the Rolls adopted. Obviously, by distinction, your reactionary relief is that which is responding to a tort that's already happening, rather than one that is just threatened. When are you going to seek injunctive relief then? Well, we've already said, broadly, if you've got an interference with property or proprietary interests, that may be a situation in which injunctive relief is on offer. Now, there can sometimes be a very fine line between when you need or should properly be seeking an injunction as compared to, say, a possession order. We're thinking here particularly cases of trespass. So strictly speaking, if you have a trespasser on the land at the time at which the order is made, the order that should be made is a possession order. However, if you're in a situation where you turn up to your what you think is a possession hearing and your trespasser has left, then actually the order you should properly be seeking is an injunction. You should be seeking injunctive relief to prevent that person from returning to the land. So it'd be some sort of precautionary relief, but it's not pure precautionary relief because it's based on past harm. You may then have those sort of grey areas where your trespasser has left, but they've left rubbish, belongings, or other detritus on the land. Or it might be a situation where they've brought belongings onto the land in a preparatory action to arrive themselves. In those circumstances, you might have a sympathetic judge who will give you a possession order, because technically leaving things on someone else's land is a trespass. But probably strictly speaking, the proper order that you ought to be seeking in those circumstances is a mandatory order to have those belongings removed. So there is a fine line sometimes between whether you should be properly seeking injunctive relief or whether you should be properly seeking something else, like a possession order. It will mostly come up in the context of trespass. And so sometimes you might need to think about alternative pleadings and cover yourself off with an injunction as well as a possession claim. Brief procedural overview then before we start the top 10 tips. The decisions that you need to make at the outset when you are thinking about bringing a claim for injunctive relief is, can we wait until final hearing, or is this something that we need interim relief for? You've probably all done cases where you've sought injunctive relief, and this is one of the very first considerations you have. Do I need injunctive relief? And if yes, can I make that application with notice, or is this so quick and so urgent that is there some other reason why we should be going without notice? And if we are going really quickly, probably without notice, is there time to issue the claim prior to issuing the application? So these are all the initial decisions that you need to start making. I'll talk more in my 10 top tips about the type of claim form that you might be using, but for most cases, you can use either a Part 7 or a Part 8 claim form. There are some types or species of injunctive relief that do need a Part 8 claim form. But when we're thinking about trespass and nuisance and the sort of torts that we might be responding to as property lawyers, you're probably in a situation where you can use Part 7 or Part 8. Of course, then you need your particulars of claim or details of claim as applicable. And if you are bringing an interim application, just remember there are two different forms. If you are going in the High Court, your application must be done by way of an N244 application notice. If you're in the County Court and you're seeking injunctive relief, you need to fill out an N16A. Hopefully, by the end of all of this, you'll turn up with an injunction order, either interim, final, or perhaps both. Be aware that there are various standard forms to which you should have regard. If you're in the County Court, it's the N16. Chancery Division, have a look at the CH11. Or if you're seeking freezing orders, for example, the annexes to Practice Direction 25A have a standard form injunction there. It may be that none of those fit the bill, or only parts of them fit the bill. So it may be that you need to do some idiosyncratic drafting, whether of the whole injunction or just elements of it. And then your final procedural step, broadly, in terms of injunctions, is you need to serve your injunction order. This is really important, and this is something that I will return to several times today. Remember, super important, the default position is that you need to personally serve an injunction order so that you can engage the contempt jurisdiction. If you cannot personally serve the injunction order, you are either going to need an order dispensing with service or an alternative service order, or at a push, you can possibly rely on the actual knowledge or the defendant's actual knowledge of the injunction order in order to engage the contempt jurisdiction. But as I say, we'll look at service in a little more detail on a couple of other slides, because it's a really important point when it comes to injunctions and procedure. So, top tip number one, or as I say, probably theme number one, where are you issuing this claim and maybe application for interim relief? There's a good chance that most claims could be started in either the High Court or the County Court, and you have to choose. Now, sometimes it will be abundantly obvious that your claim properly belongs in the High Court. So if you have questions of complexity, whether they be complex questions of fact or law, then you should be looking at the High Court. Or again, if you have questions of public importance, you should be looking at the High Court. Sorts of injunctions that are going to the High Court at the moment, almost as a matter of course, are those trespass injunctions that have a particularly wide scope, or those injunctions which capture persons unknown, especially where, again, they're particularly wide in scope. So, for example, and I'll keep using this as an example because it's something I do very regularly, protester injunctions properly belong at the moment in the High Court because the law is in such a state of flux and there's lots of important developments going on. So those sorts of cases should properly belong in the High Court. Other times it's not going to be so clear which court you should be in, and you could probably choose either. And in that situation, you might need to have regard to sort of more soft considerations. So, for example, is your case particularly urgent? Does it need to be heard, sooner rather than later? Do you need the assistance of an interim or an urgent applications list? If so, that might push you more towards the High Court because the High Court facilitates that very well as compared to some county court setups. If you're going High Court, you probably need to make a decision as to whether you're going King's Bench or Chancery Division. Some claims have to be brought in the King's Bench and actually have to be brought in a very specific division of the King's Bench. Chances are, if you're doing sort of trespass or nuisance type injunctions, you won't necessarily encounter these. The two big ones to be aware of are any injunctions that have an element of harassment in them. They properly belong in the King's Bench. And if you're also seeking an injunction to restrain harassment by publication, that also belongs in the King's Bench and it belongs in the MAC list. It sounds like, at first glance, that might not trouble you. However, if you're seeking to restrain what a trespasser is doing on the land, so you're seeking to restrain things that they might be saying or things that banners that they might be holding, things like that, you might actually find that you do fall into one of these categories. So just keep an eye on those. However, for your nuisance and trespass type injunctions that don't have any of that element to them, you're probably thinking your more natural home is in the Chancery Division. Just keep an eye though on who your claimant is. If you have a claimant who is seeking an injunction under a specific statutory provision or statutory power, and so specifically thinking here maybe a local authority, and there's provisions such as section 222 of the Local Government Act, that claim might have a more natural home in King's Bench as opposed to Chancery. And then also just consider the practical arrangements. If you are doing something particularly urgently, and especially if you're doing it out of hours, you might think actually the most sensible thing to do is to go to the court with which you are most familiar. You'll be more familiar with the processes, how it works, and you might just find that some courts facilitate that sort of business better than others. You'll find that out through experience, or whoever you instruct will probably have experience of both options and will be able to guide you there. Top tip number 2, already mentioned it, which claim form are you using? Most claims can be started by way of Part 7 or Part 8 claim form. Examples, it sounds really simple, but there are some claims that have to be started by way of Part 8 claim form. We all know this, but in the heat of the moment, when we're moving very fast, things like that can be easy to forget. 2 in particular that you might need to be aware of: if you're seeking an injunction under section 187B of the Town and Country Planning Act 1990, which you may be if you are acting for a local authority and you're responding to trespasses by unauthorised encampments, that has to be started by way of a Part 8 claim form. And again, if you've got any sort of harassment element to your injunction, again, Part 8 claim form. So don't just discount harassment and think it doesn't ever come up. It may well come up in these contexts, especially with trespassers and nuisances. So yes, keep an eye on whether there is a rule that pushes you towards Part 8 as opposed to Part 7. Other than that, it's your usual, is there a substantial dispute of fact type question when you're choosing whether to use Part 7 or Part 8. I think generally, if you are seeking precautionary relief to restrain a threatened trespass or a threatened nuisance, and you're seeking it on the basis of past harm that's been suffered, there's a good chance that that could probably be dealt with by way of a Part 8 claim form. It could probably be dealt with more efficiently that way, especially if you have a small number of defendants, and especially if you can name them all. So I would consider using the Part 8 procedure if possible, and if it's appropriate to do so. On the subject of defendants, this is top tip number 3. As a general rule, you should be striving to name all of your defendants. That would be the ideal world. Unfortunately, we don't live in an ideal world. That's not always possible. So you may need to have a category of persons unknown on your claim form. Now, that's very important. It's a category of persons unknown. You cannot simply bung on the top of the claim form persons unknown as a defendant. That's not acceptable. You have to define the category. And you have to define them by reference to their conduct, which is alleged to be unlawful, without express reference to legal concepts. And so, for example, you can't use trespass in your definition of persons unknown. You can't say persons unknown who are trespassing on Blackacre. What you instead need to say is persons unknown who are entering or remaining on Blackacre without the consent of the claimant. As a general rule as well, you should be avoiding referencing the subjective intention of the defendants in your definition of persons unknown. What's become quite popular in the last couple of years is to use this for the purposes of type clause in your definition. So persons unknown who are entering or remaining on Blackacre for the purposes of protesting. It's become quite common in protester cases. The reason why we use this is it narrows down the scope, or it narrows down the width of your category of persons unknown. Anything that you can do to narrow the width and really target the injunction will be welcomed by the courts. The courts are very keen not to have these wide-ranging injunctions that capture absolutely everybody. You need to try and focus on your targets. And the big thing at the moment when it comes to persons unknown and persons unknown defendants is, at the moment, the law is such that you can have both interim and final relief against persons unknown. and specifically here, persons unknown newcomers. So those people who are unknown and unidentified at the time at which the order is made. The pendulum's been swinging here for several years, and it's currently on appeal to the Supreme Court. So the appeal was heard in February 2023, so it's now known as the Wolverhampton City Council case, and judgment is still awaited. But at the moment, the position is you can have both interim and final injunctive relief against persons unknown. Number 4, interim hearing. As we've mentioned, you may need to go without notice, or you may have the option and the luxury of being able to give notice. Don't think it's a binary choice, because it's not. There is, various options in between that you can choose. And actually, again, these are becoming quite popular in the protester injunctions. So it may be that giving an email or a phone call a couple of hours before the hearing with a remote link by which people can attend is that sort of thing is being encouraged in some of the injunctions sought against protesters at the moment. Don't think you're looking at a binary choice. There are various options in between, and the court might be grateful and look upon you quite favourably if you think about using some of those options in between. If you do go without notice, I know you know this, but remember your duties of full and frank disclosure. And very importantly, and again, I know you know this, but make sure someone is sitting there making a full note of the hearing. It's good practice in any event, but it's particularly important because if you utter without notice hearing, you should expect to have to give an undertaking that you will serve that note along with the claim form, the application, and any order that's made at that hearing. Now, most injunctions with which we're going to be concerned, so trespass, nuisance, they will probably just engage the American cyanamid principles, with which we are all familiar. However, just be aware that if you are seeking relief that might affect the Convention right to freedom of expression, the Human Rights Act Section 12 might be engaged. And again, this might be engaged if you're trying to restrain what a trespasser is doing on land. So if you're trying to restrict them from holding particular banners, saying particular things, spray painting particular messages, you might find that actually you are captured by the Human Rights Act. So it's worth having a look at, it's worth being aware of. 2 particular sections to be alert to. Section 12, subsection 2. There are particular requirements there that you must meet if a defendant is neither present nor represented at your interim hearing. And also, have a look at section 12.3, because it's particularly important because it changes the test that applies. You'll not be dealing with American cyanamid anymore. If you are seeking relief that will restrain publication before trial, publication being defined really widely and might capture standing with banners, spray painting messages, then actually the test is we have to show that the claimant is likely to establish that publication should not be allowed at trial. So a higher threshold than American cyanamid. So don't get caught out there. You're trying to restrict what trespassers are doing when they come onto the land. You may actually find yourself captured by the Human Rights Act. Top tip number 5, the substantive order. I've put 2 cases on the slide here, Ineos and Quadrilla. They're both persons unknown cases. They both set out requirements of an injunction order in relation to persons unknown, but they are important requirements that you can properly read across into named defendant orders as well, insofar as bits are relevant. In particular, in Ineos, there are 6 requirements, as I say, which are set out in relation to an order against persons unknown. But in particular, what you can read across are requirement number 4. The terms of the injunction must correspond to the threatened tort and must not be so wide that they prohibit lawful conduct. And also requirement number 5, the terms of the injunction must be sufficiently clear and precise as to enable persons potentially affected to know what they must not do. So striving for clarity in our injunctions, pushing away ambiguity, making sure everyone knows what obligations are incumbent on them. Quadrilla caveats those Ineos requirements, and actually we learn from Quadrilla that you can prohibit conduct that's not otherwise tortious or unlawful if doing so is the only way to protect the rights of the claimant in your particular case. As we've mentioned, you're not always going to be seeking prohibitory relief, though. You might be seeking mandatory relief. If you are seeking mandatory relief, make sure that your injunction unequivocally states what the defendant must do and also a deadline by which they must do it. Top tip number 6, alternative service. This is incredibly important. This would have been nearer the top if it had fallen in the chronology closest to number 1. When you are seeking injunctive relief, one of the very first questions you need to ask yourself is, do you need the assistance of an alternative service order? And if so, what do you need it to apply to? Is it the claim, the application, the injunction order itself, or all of the above? It's particularly important in injunction cases because, as I've already mentioned, to engage the contempt jurisdiction, you must either personally serve your injunction, obtain an order dispensing the service, serve with the assistance and in accordance with an alternative service order, or you might then have to rely on the defendant's actual knowledge of the order. So it's really important to understand very early on in the case how you're going to be serving the order that you're looking for at the end, because if you can't serve it properly and you don't serve it properly, you're simply not going to be able to enforce it by way of committal proceedings. It's your usual principles of alternative service that apply. So CPR 6.15 and 6.27 are your go-to sources. In particular, make sure you remember 6.15 sub 4. This goes missing in quite a lot of alternative service orders. So don't forget, your order must state the method or place of service, as you would expect. And then the two things that tend to go missing, you must also state the date on which the claim form or other document is deemed served. So you need a deeming provision in your alternative service order. And then you also need a date on which or by which an acknowledgement of service, admission or defence must be filed if your alternative service provision relates to a claim form. If you do have an alternative service order, be very aware that you must comply strictly with the letter of that alternative service order. It's not good enough to say, oh, we complied with the spirit, or, oh, we think we did something actually better, so that's fine. The court will not allow that. The court will not say you complied with service. That will not be good service. And the court was very clear on this in the NBR Akers and the given decision. The test that you need to meet when you are seeking an alternative service order is that set out by the Supreme Court in Cameron. And the test is the mode of service should be one which can reasonably be expected to bring the proceedings to the attention of the defendant. Top tip number 7, I'm aware of the time, don't worry. Top tip number 7, other essentials for your order. It's an injunction. If you want to commit on it or enforce it by committal, you're going to need a penal notice. There are suggested wordings for penal notices in the CPR or in the commentary to the CPR. They're slightly hidden. They're in the commentary at Rule 81.4. So Rule 81.4 being the section that sets out the requirements of a contempt application. That's where the wording for penal notices is hidden. There is no particular magic wording, but there's an irreducible core that you're looking for. If for some reason you don't have a penal notice, you've forgotten or it's just fallen off somehow, something like that, the absence of a penal notice is a defect that can be waived on a committal, but you would need to show that there's no injustice being suffered by the defendant. So really you're looking at circumstances where the court has explained to the defendant the consequences of breaching the order. Only in those circumstances would there be no injustice to there not being a penal notice. There's quite a lot of case law surrounding penal notices about where it needs to appear on the order. Generally speaking, it should actually appear on the front page of an order. That's not always possible, especially if you have a particular long defendant or claimant list, particularly long titles. My general practice is if I can't get it on the first page of an order, I will make sure I type it out in red. So it's obvious when you turn the pages that there is something there that needs looking at. We already mentioned the standard form injunctions, so the CH11, the N16, they have some suggested penal notice wording in there as well. Other essentials you might need to consider including a liberty to apply clause. So generally speaking, you should include one of those whenever you have an injunction against persons unknown, whenever you seek an injunction without notice or in circumstances where you have a defendant who hasn't attended a hearing, I would draft the clauses quite fully. So I wouldn't just say liberty to apply. I would say liberty to apply on 72 hours written notice to all parties, something like that. Be very specific about the time span for making such applications and what the expectation is. And lastly, consider using a review clause, especially if you've got an interim that you actually expect to be sitting on for quite a long time. If you're looking at your proceedings and think, actually, these are going to take years to come to final hearing, consider having a review clause. The courts are liking these at the moment. So, maybe bring the injunction back every year to be reviewed by the court to see if there needs to be any variation or discharge. That might be, appropriate. And if you've got a final order, consider whether actually it being a perpetual final order is appropriate. It might be that actually a time limited order is more appropriate in your circumstances. So, do you need it forever, or is a period of 5 years sufficient? And those two considerations are especially important in persons unknown injunctions. Top tip number 8, undertakings. Very quickly, if you are acting for a claimant local authority and the action involves their duties of law enforcement, the position is that the court should consider exercising its discretion not to require a cross undertaking of damages. That's the Kirklees decision, long-standing decision in Kirklees. It would be very, very rare to have a situation where a local authority is asked to give an undertaking in damages. In terms of undertakings that dispose of the proceedings, as a general rule, claimants should consider trying to get undertakings from defendants. Generally speaking, if a defendant is willing to give an undertaking in exactly the same terms as the injunction order that you're seeking, there is no reason not to accept that undertaking. It's enforceable in exactly the same way as an injunction is, so you can enforce by way of committal. There are a few circumstances where an injunction might give you a little bit more. So a Harassment Act injunction, for example, you might be able to attach a power of arrest to. But certainly for trespass, nuisance, the more straightforward pure property type injunctions, there's probably going to be no difference between an undertaking and an injunction. If you are accepting an undertaking or asking for an undertaking, remember the undertaking is given to the court, not the claimant. And if the undertaking is not being given in the context of a wider settlement or compromise between the parties, remember that all of these other peripheral issues, such as costs, will still remain at large. And the giving of the undertaking should really, best practice, Court of Appeal guidance says, be recorded in an order. So the fact that an undertaking has been given should be recorded in an order. That order should be sealed and served in the ordinary way. And actually in that order, that's where you can deal with your peripheral issues if necessary, such as costs. Almost there. Top tip number 9, progress the proceedings. This is also incredibly important. This is up there with service as being super important. Once you have got your interim order, do not disappear into the sunset, never to be seen again. That is a surefire way to come under allegations of abuse of process. Make sure that you are progressing your proceedings. That doesn't necessarily mean that you have to progress to a final hearing. The circumstances of your case might be such that that's not really on the cards. For example, I've mentioned this idea of review clauses. It might be that the court is more comfortable in your situation with having a rolling programme of short time-limited interims that it reviews every year, for example. So what's really important is that you have active case management. Do not just disappear with your interim and sit on it and allow your case to go dormant. That is absolutely not the thing to do. Active case management is key here. And finally, top tip or theme number 10, enforcement. So injunctions and undertakings can be enforced by way of committal proceedings for contempt of court. So when you are serving and monitoring compliance with the injunction, always have the requirements of a contempt application in mind. If you're not ever thinking about enforcing your injunction, then you shouldn't be asking for one. And the court may not grant it if it sees there are lots of breaches happening and you're just sitting on those breaches and not looking to pursue them. Committal proceedings are governed by Part 81 of the CPR. There's a new version in force from October 2020. And remember that your burden of proof is beyond reasonable doubt. And I keep stressing it, but it's incredibly important. The claimant must prove service of the injunction, whether by personal service or with the assistance of alternative service order, or if you really have to, you might be able to prove actual knowledge of the injunction order. And you need to prove that to engage the contempt jurisdiction. And only then do you actually need to worry about the substantive elements of the alleged contempt. So always make sure you are completely comfortable with service. Service is the thing that you really must get completely right when it comes to injunction orders. And then the thing we all want to know about contempt, what's the maximum penalty? Maximum penalty is 2 years imprisonment and or an unlimited fine. So those are my sort of 10 top themes for injunctive relief. I shall stop sharing my screen and bring Louis back.
Great, thanks very much. Well, thank you everyone for attending. As Natalie said earlier, please don't hesitate to get in touch with any questions. You'll be able to reach us via the website. This talk will be posted on YouTube, where you can also find an archive of all the other junior programme talks that we've done. So with that, I hope you have a good afternoon, and thanks very much again for attending.